So recently, Louis Rossmann has talked about the Apple MacBook Flexgate situation, and what we have for you today is an order granting in part and denying in part the motion to dismiss the Second Amendment complaint. So Apple tried to have the case dismissed, and Apple is not successful in having the case dismissed. So that's where we are in this case. The plaintiff has made their complaint, and instead of answering the complaint and beginning the litigation process, Apple has made a motion to dismiss the complaint. And Apple has failed to get the complaint dismissed and will have to go through with the discovery process if the case doesn't get settled. In 2016, Apple introduced its updated 13 and 15-inch MacBook Pro models. To make these MacBook Pros thinner and sleeker than their predecessors, Apple used thin, flexible backlight ribbon cables to connect the lighting mechanism of the display screen to the display controller board. These backlight ribbon cables wrap around the display controller board at the hinge of the laptop and are secured by a pair of spring-loaded covers. This configuration causes the backlight ribbon display cables to rub against the control board when the laptop is opened and closed. Over time, the rubbing causes the cables to tear, which leads to various problems with the display screen. For example, the tearing of the cable can cause a stage lighting effect, consisting of alternating patches of darkness along the bottom of the display. Further tearing can lead to more serious display issues, such as large blocks of color that obscure portions of the screen and eventually can cause the display to fail entirely. To varying degrees, these issues with the display screen all allegedly render the laptop unusable and unfit for its ordinary purpose. Plaintiffs allege that the backlight cables tear because they are too short and do not provide enough slack to withstand the repetitive opening and closing of the MacBook Pros. Faced with complaints from numerous consumers about the stage lighting effect and failure of the display, Apple attempted to remedy the alleged defect by making the backlight cables 2 millimeters longer in July 2018. In May 2019, Apple introduced the MacBook Pro Display Backlight Service Program, through which Apple agreed to replace the display on all 13-inch 2016 MacBook Pro models that exhibited the stage lighting effect or total failure of the display backlight system. Under the service program, Apple will refund the owner of a 13-inch 2016 MacBook Pro who have paid to have the display fixed. Good, but that's May of 2019, so you've gone through years of problems with your laptop potentially, and then Apple finally says, oh, okay, now we'll fess up to us causing a problem. I had the same problem with my iPhone 5, I think it was. I had the lock button issue, and Apple refused to replace it at first, and then eventually, like a year later, they said that they would replace it under a program, but then of course I had some wear and tear on my phone by then, and they said that a tiny little chip in the corner of the glass of my screen meant that I could not have it replaced without paying for a new screen. I said no, just put the screen back together as is, and they said no, we're not going to be responsible for that, so we're not going to pay for your repair. And that was the last time I ever did business with Apple. And you've seen how well my boycott worked for getting what I wanted, right? But still, on principle, I don't want to do business with the company. Plaintiffs are all owners of a 2016 15-inch MacBook Pro or one of the models released after, and allege that their laptop suffered from those problems. In all cases, these issues manifested after the one-year warranty expired. Plaintiffs bring these claims for violations under the California Unfair Competition Law, the equivalent deceptive trade practices laws in Alaska, Florida, Massachusetts, Michigan, Missouri, New Jersey, Texas, and Washington, violations of the Song-Beverly Consumer Warranty Act, breach of the implied warranty of merchantability under those same states' laws, and Apple then seeks to dismiss all the plaintiff's claims for lack of subject matter jurisdiction and for failure to state a claim upon which relief can be granted. Now, I'm going to skip a little bit ahead. We know what the legal standard is for a motion to dismiss. And on a motion to dismiss standard, we're going to look at the plaintiff's pleadings in favor of the plaintiffs. If there is any doubt as to what a vague term or claim means, we're going to find in favor of the plaintiff just for the purposes of the motion to dismiss. So the motion to dismiss is just a threshold inquiry. It's a beginning barrier to entry that says, does this plaintiff make out a basic case? First, Apple argues that the four named plaintiffs lack standing because they did not suffer any injury, in fact, cognizable under the law. Apple asserts that, contrary to their allegations, plaintiffs did not personally purchase their MacBook Pros. Apple cites no authority suggesting that a person must be the original purchaser of a product in order to have standing to bring claims related to that product. Indeed, there are innumerable ways in which an economic injury from unfair competition may be shown. That's from the Grace v. Apple case. So the judge has decided to cite to a case that involved Apple, as in, like, that's a little bit of a slap to the face, like, hey, you're making an argument, but you already had a case about this that went against you. Plaintiffs both allege that they incurred concrete economic injuries by paying to repair or replace their laptops after the screen became inoperable. The court finds that these economic injuries establish an injury in fact sufficient for standing. Apple argues that a different plaintiff lacks standing because it already replaced the display free of charge. Apple testified that based on a review of Apple repair records, the entire display assembly, including the backlight cable, was replaced in June of 2020. Apple does not point to anything in the document that indicates that the display was actually replaced pursuant to the diagnostic. Indeed, the plaintiff submitted a declaration stating that Apple did not replace his entire display assembly free of charge in June of 2020. So interesting that Apple is saying they replaced the display and the guy's saying they didn't. He further stated that he took his device to an Apple authorized service provider, which diagnosed his screen failure and charged him $771.80 for the replacement of a display. So this is, I guess, what the heart and meat of the matter is. Apple doesn't want to have to replace these displays and give up $771.80 of authorized service provider revenue. If they don't admit to the problem, then they don't have to give up that opportunity cost. Apple as a company is very good at design, and honestly, I don't understand why they don't take responsibility for their design flaws. They are one of the richest companies in the world, and certainly there's an argument that you don't get to be the richest company in the world by giving away all your money. But what am I going to do? Switch to Linux? I could go back to Commodore. Based on the evidence, the court is satisfied that that plaintiff, Mr. Knudsen, did, in fact, experience economic injury. Apple also argues other plaintiffs lack standing, this time because the plaintiff purchased the laptop later on July 20th, 2018, and Apple said that they had fixed the design problem by then. But then the plaintiffs counter by saying that they discovered that the 2018 models had the same display issues as prior models, despite the longer backlight cable Apple had incorporated. They allege that plaintiff began experiencing display problems in March of 2020, 2 months before the original complaint was filed, that his device became inoperable of June 2020 after the complaint was filed. The court finds it plausible that plaintiffs originally believed the issue to have been remedied by the longer backlight cable and only realized the issue had not been resolved when the 2018 displays began failing. Thus, the court finds no contradictions in plaintiffs' original allegations. Apple next argues that plaintiffs' purported injuries are not fairly traceable to Apple's alleged conduct, because 7 of the plaintiffs' devices do not even contain the alleged design defect. Specifically, Apple argues that plaintiffs' claims are based on the factual misconception that the backlight cables were substantially similar to those in the 13-inch 2016 MacBook Pro device. I think we're talking about the 2018 models then, that is eligible for Apple's service program. Apple argues that plaintiffs concede that the relevant aspect of design is the length of the backlight cables. They are allegedly 2 millimeters too short. Apple then asserts that because the backlight cables in 7 of 9 of the plaintiffs' MacBook Pro devices are at least 2 millimeters longer, there is no causal nexus between the 7 plaintiffs' purported injuries. So they're saying because the plaintiffs couldn't guess what the cause of the problem is, then they haven't made a claim. This argument fundamentally mischaracterizes plaintiffs' theory of liability, says the court. Plaintiffs allege that the backlight cables in their devices are too short, not that they are 2 millimeters too short. Plaintiffs allege that the placement and configuration of the backlight cables in the 15-inch MacBook Pro is substantially similar, if not identical, to the placement and configuration of the cables in the 13-inch MacBook Pro, but nowhere do plaintiffs allege that the cables used in each model are the same length, or that all defective cables are precisely 2 millimeters too short. Plaintiffs allege that Apple attempted to remedy the defect in the July 2018 models by using a cable that is 2 millimeters longer. According to plaintiffs, these 2018 models suffer from the same alleged defect. Next, Apple argues that 5 of the plaintiffs' injuries are not traceable because the types of display issues they are experiencing are not symptoms that are the subject of the display backlight service program. Apple argues that the vertical pink lines that plaintiffs experienced are not attributable to this defect. It being a plaintiff's complaint, Apple does have the right to come back and say, well, you said this was a problem with the backlight, and then you have pictures in here and claims that relate to problems that are not with the backlight. You have to make those claims explicit. Remember, the object of a lawsuit is for you to build a record to support your claim so that a judge or jury can find in favor of you on the facts, and then the judge can rule as a matter of law that those facts fit into a law that creates a remedy, and you're supposed to then get paid, or some injunctive remedy. And so if you only said, I have a problem with my backlight cable, and Apple's like, okay, well, fine, we'll fix your backlight, but we're not going to fix these problems that you didn't properly plead. That's, if I was Apple's lawyer, I'd probably do that. But yeah, the rest of us sideline quarterbacking can look at this and say, yeah, the cable's the display cable. You probably don't need this entire mechanism here just for the backlight. This is probably carrying the display signal, and so if really any part of this separates and no longer functions, the symptom of the problem will present depending on what part of this cable is severed or broken. It'll be either a display problem or a backlight problem, a power problem, both, all three. And that's just not the way it's been pled in the second amended complaint. So that's what Apple's attacking there. Finally, Apple argues that, according to its internal records, another plaintiff experienced a flickering violet light and not the stage lighting effect as alleged in the second amended complaint. This argument fails for several reasons. First, plaintiff's declaration, on which Apple relies, does not reference or attach any evidence to support the conclusions about what symptom the alleged defect does or did not cause. Apple declares that the symptoms certain plaintiffs experience are not traceable to the backlight issue that is the subject of the backlight service program, without offering any reason, evidence, or explanation for that legal conclusion. Without more, the court is not persuaded that plaintiff's injury is not traceable to Apple's alleged conduct. So Apple has made the mistake in reverse and has not shown their work, offered the legal proof. They've just made the conclusion, well, hey, those pink lines or those lines on the screen or whatever, those aren't part of the backlight problem. And the judge is like, okay, but you have to show your work. And they didn't. Second, Apple's witness draws the conclusion that plaintiffs did not experience the relevant symptom based on the fact that the plaintiff did experience other symptoms. And Apple's witness concludes that they are unrelated to the defect. Plaintiffs specifically allege that both plaintiffs experienced the stage lighting effect as well. The fact that plaintiffs may have experienced more severe display backlighting system failures, as illustrated in the photographs, does not mean those plaintiffs did not also experience the stage lighting effect. So Apple's trying to say that the stage lighting effect, or the complete dropout of the backlight, is the problem that was alleged, and by showing pictures of other problems, that means you didn't have the backlighting problem, and the court is saying, no, you can have both problems. Plaintiffs need not have included photographic evidence of every display issue they faced, nor do the photographs that are included limit the allegations plaintiffs may raise about other symptoms. Similarly, the fact that one plaintiff did not report experiencing the stage lighting symptom to Apple does not justify a conclusion that he did not experience that symptom. Remember, we're on the motion to dismiss stage here. You don't even have to present pictures. The pictures are just there to help illustrate what your claim is. You can just present a short, plain statement of the facts with jurisdiction in there someplace, and with the legal remedy, the law and the legal remedy that you're claiming, the counts or claims. So as long as you've got those things in there, jurisdiction, short plain statement of the facts, and a law that gives you a remedy, that should meet the Rule 8 pleading standard, and you should be able to have a federal lawsuit sustained, provided that you've done all that correctly. Even assuming that the witnesses' conclusions about plaintiff's issues are true, those conclusions are not dispositive of plaintiff's standing. Whether plaintiffs with the benefit of discovery will ultimately be able to prove that the alleged defect caused their problems is purely a merits-based question. The court declines to decide the merits of plaintiff's claims within the context of a standing inquiry. Finally, every one of plaintiffs alleged that their display backlighting system eventually completely or otherwise became inoperable. Apple even acknowledged that the 13-inch MacBook Pro display backlight service program covered 13-inch 2016 models that experienced stage lighting effect or a total failure of the display. Thus, even if the symptoms covered by the 13-inch MacBook Pro display backlighting service program were relevant evidence in causation of the case, plaintiffs all experienced at least one symptom, failure of display, that is covered by the service program. Then there's a fraud-based claim in here, so fraud must be pled with particularity. That's Rule 9b that the court is talking about here. Particularity means that you must give specific enough pleadings to give defendants notice of the particular misconduct which is alleged to constitute the fraud. Apple argues that plaintiffs' claims for fraudulent concealment and Deceptive Trade Act claims are all grounded in fraud. Plaintiffs do not raise any arguments to the contrary, but maintain that the omission-based fraud claims are held to a lesser standard and that 9b's particularity requirement does not apply. The court agrees that the heightened pleading with particularity does apply. I'm going to guess this gets dismissed then. Apple argues that plaintiffs failed to allege that their display issues are the result of a defect. Yeah, we got that part. But the court disposes of that argument. Then plaintiffs allege that Apple committed fraud by making affirmative misrepresentations about the MacBook Pro display. Apple counters that to the extent plaintiffs' fraud claims are based on Apple's misrepresentations, plaintiffs failed to plead those misrepresentations with sufficient particularity. Apple argues that these allegations omit virtually all of the detail necessary to satisfy Rule 9b. The court disagrees. The court finds that plaintiffs adequately allege the who, Apple, the when, before plaintiffs purchased their devices, and the where, Apple's website, of the affirmative misrepresentations they allegedly relied on. Plaintiffs adequately alleged that what they saw were Apple's advertisements and marketing materials and give particular examples of such materials, including an October 2016 press release of an image of Apple's online advertisement related to these displays. That together, these allegations are sufficient to give Apple notice of the particular misrepresentations which are alleged to constitute fraud. Apple next argues that the affirmative misrepresentations are not actionable because they constitute puffery. A challenged claim is non-actionable puffery if it is a generalized, vague, or unspecified assertion upon which a reasonable consumer could not rely. An actionable statement must make a specific and measurable claim, capable of being proved false, or of being reasonably interpreted as a statement of objective fact. Whether a statement is puffery is a question of law. Plaintiffs argue that Apple's statements in this case are not mere puffery when viewed in the context of Apple's promotional campaign for the MacBook Pros, which stressed that the new display screens are the best in the computer industry. Plaintiffs cite to Bayer versus Symantec Corporation, in which the court found Symantec statements that its software was industry-leading to be actionable. The court in that case explained that industry-leading could lead a reasonable consumer to believe that Symantec software would adhere to industry best practices, especially where the alleged defect violated Symantec's express cybersecurity best practice guidelines. Unlike in Bayer, the statements in this case that the MacBook Pro display is the best Mac display ever does not imply Apple's adherence to industry best practices, and in fact only compares the display to other Macs, not to the industry at large. Thus, the court finds Apple's statements that the laptops are revolutionary, groundbreaking, offer breathtaking. Hi, Keanu Reeves.
You're breathtaking.
Thus, the court finds Apple's statements that the laptops are revolutionary, groundbreaking, offer breakthrough performance, and contain the best Mac display ever to be subjective, immeasurable assertions constituting non-actionable puffery, because they say nothing about the specific characteristics or components of the computer. The only actionable statements plaintiffs allege are from the 2016 MacBook Pro advertisement, which states that the display is 0.88 millimeters thick, operates at 500 nits of brightness, is an amazing 67% brighter than the previous generation, features 67% more contrast, and is the first Mac notebook display to support wider color gamut. These more specific statements about the objective characteristics of the devices are actionable because they are capable of being proven false. While these statements may be actionable in theory, plaintiffs do not allege that they are false. Plaintiffs' theory is that the backlight cables connecting the lighting mechanism and the display screen are too short, which causes them to tear prematurely, which in turn causes display problems and failure. Nothing about this alleged defect relates to the thickness, brightness, or color gamut of the MacBook display. The court grants, without prejudice, Apple's motion to dismiss plaintiffs' fraud claims. So being dismissed without prejudice means that the claims are still alive, but they're not part of this lawsuit until the plaintiff brings them back. Then they also go over fraud by omission, as in Apple knew there was a defect and did not disclose the defect. Plaintiffs argue that Apple's failure to disclose the alleged defect was material because a reasonable consumer would have found information about the alleged defect important when choosing to purchase a laptop. A non-disclosed fact is material if the omitted information would have caused a reasonable consumer to behave differently if he or she was aware of it. Accepting as true that the alleged defect will cause all class members' laptop displays to fail eventually, as the court must at the pleading stage, the court finds that the omitted information is material. Plaintiffs argue the alleged defect is central to the laptop's functioning. Plaintiffs argue that Apple had a duty to disclose because it had exclusive knowledge of the alleged defect. Plaintiffs point to their allegations that Apple is aware, has been aware of the defect in its backlight ribbon display cables because it received complaints from numerous consumers about the display lighting effect and the failure of the display, and because intensive pre-release testing would have alerted Apple to the tearing and ultimate failure of the backlight ribbon cables. Apple points out that each of the consumer complaints excerpted in the Second Amendment complaint were posted after all of the named plaintiffs purchased their laptops, but plaintiffs allege that the comments excerpted are a small sampling of tens of thousands of comments and reports related to the stage lighting effect or display failure in the MacBook Pros. Apple argues that pre-release testing alone is not enough to establish knowledge of a defect and cites to several court cases. In the Burnt versus Whirlpool case, the court concluded that plaintiff must allege more than an undetailed assertion that the testing must have revealed the alleged defect in order to establish exclusive knowledge. In this case, plaintiffs allege several additional details about the pre-release testing that Burnt lacked. Plaintiffs allege that the pre-release testing was done by a team of reliability engineers who specifically executed reliability tests on Apple technologies such as stress tests, and developed new test procedures to quantify the reliability of a design and failure analysis resulting from these tests. These allegations about who conducted the tests, what type of tests were done, and what type of results analysis was performed support plaintiffs' conclusion that this intensive pre-release testing would have alerted Apple to the tearing and ultimate failure of the backlight ribbon cables. Finally, to sufficiently plead reliance on a fraudulent omission, a plaintiff must show that had the omitted information been disclosed, one would have been aware of it and behaved differently. Plaintiffs in this case allege that they visited the Apple website prior to purchasing or becoming owners of their laptops. Plaintiffs further allege that had they known about the alleged defect, they would not have purchased their laptops or would not have paid the price they paid. The court finds these allegations sufficient to demonstrate reliance. Because plaintiffs have adequately alleged that Apple omitted material information that it was under a duty to disclose on which plaintiffs would have relied, the court finds that plaintiffs have sufficiently alleged their omission-based fraud claims. The court denies Apple's motion as to the omission-based deceptive trade practice claims. So the fraud claims survive. Implied warranty claims. Plaintiffs allege that Apple breached the implied warranty of merchantability under various state laws. Sellers in each of the relevant states, in this case, may modify or exclude the implied warranty of merchantability with a conspicuous disclaimer. Apple's limited warranty states in clear language that Apple disclaims all implied warranties, including warranties of merchantability. Because the plaintiffs do not dispute the accuracy of the limited warranty, and because the limited warranty effectively prevents plaintiffs from bringing implied warranty claims, the court grants the motion and dismisses the implied warranty claims with prejudice. The Song-Beverly Act provides that every sale of consumer goods that are sold at retail in California shall be accompanied by the manufacturer's and retail seller's implied warranty that the goods are merchantable. To state a viable claim under California's Song-Beverly Consumer Warranty Act, a plaintiff must plead sufficiently a breach of warranty under California law. Generally, the warranty of merchantability ensures that goods are fit for the ordinary purpose for which such goods are used. The mere manifestation of a defect by itself does not constitute a breach of the implied warranty of merchantability. A plaintiff who claims a breach of the implied warranty of merchantability must show that the product did not possess even the most basic degree of fitness for ordinary use. So a much clearer case would be if someone is selling you a measuring cup for use in your kitchen and it has holes in it, and you go to put liquids or solids into the cup to measure it and they just fall through the bottom, but it was sold to you as being a measuring cup for use in the kitchen. Well, that's not merchantable as a cup for measuring because nothing stays in the cup. I mean, that's pretty obvious. If you saw a cup with holes in it, well, more than the hole in the top for putting stuff in, you would probably not buy that cup. That aside, that's a clearer example. The computer that Apple sold, I'm going to guess, was merchantable, as in it works as a computer. It's just also got this latent defect. So I don't think that's going to violate the warranty of merchantability because it was merchantable when it was sold. It just wore out faster than it was supposed to because of a design defect. Let's see what the court has to say. Plaintiffs allege they sufficiently stated a Song-Beverly claim because the MacBook contains a defect that renders the laptop unfit for ordinary purposes. Apple argues that the plaintiffs admit that he used his MacBook for 3 years, including for 2 months after the defect manifested. Thus, Apple argues that the alleged defect did not render the laptop unfit for even the most basic degree of ordinary use, and the court agrees. While the display issues the plaintiffs faced were certainly disruptive to his use, the fact that he continued to use his device for some time after the symptoms began indicates that a device was still fit for basic use. Therefore, the court grants the motion on plaintiff's Song-Beverly Act claim with prejudice, dismissing that claim. There are other claims, the unfair competition claim, I think. Under the unfairness prong of the unfair competition law, a practice may be deemed unfair even if not specifically prescribed by some other law. California has developed 2 tests for unfairness, a tethering test which requires that the public policy, which is a predicate to consumer unfair competition action under the unfair prong of the UCL, must be tethered to specific constitutional, statutory, or regulatory provisions. Okay. And 2, the balancing test, which examines whether the challenged business practice is immoral, unethical, oppressive, unscrupulous, or substantially injurious to consumers, and requires the court to weigh the utility of the defendant's conduct against the gravity of the harm of the alleged victim. For the reasons stated above, Apple's motion is granted in part, denied in part. The court finds that plaintiffs have standing and have adequately stated their deceptive trade practice claims and fraudulent concealment claims to the extent those claims are based on alleged omissions. The court finds that plaintiffs failed to adequately allege their deceptive trade practice claims and fraudulent concealment claims to the extent those claims are based on affirmative misrepresentations, and dismisses those claims with leave to amend, so we could get a 3rd amended complaint. The court otherwise grants the motion and dismisses plaintiff's remaining claims with prejudice. So plaintiff can file an amended complaint if they want by no later than April 16th, 2021. And I'm looking at the docket now and I don't see an April 16th 3rd amended complaint, so I guess they are fine with dropping those. And so yeah, that's positive news for the Apple Flexgate case. Perhaps these plaintiffs will be able to prove some of these claims after the discovery of relevant information. So now Apple has to answer the remaining claims yes or no, we agree or disagree, affirm, denied, and then the court and the parties will schedule the progression of the case, probably over the course of the next 2 or 3 years. And in the middle of that will be the discovery of relevant information. Expert witnesses will be disclosed. The plaintiffs will get information from Apple about their claims. Apple will be able to get information from the plaintiffs about Apple's defenses. And then someone will probably make a summary judgment motion, or perhaps the parties will reach a settlement. Ultimately, this kind of thing is probably best settled. Apple obviously has enough money to be able to take care of the problems Apple's designs cause. So unless Apple has a meritorious defense, it shouldn't be fighting this and should be settling this. Of course, settlement takes 2 parties. So who knows if the parties will be able to work together to reach an agreement. Maybe the plaintiffs will be asking for an amount that Apple could not agree to. Either way, positive news for Flexgate. Let me know what you think in the comments below. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv at Sunday mornings at 10 a.m. Eastern Time. This is a community-supported legal education channel, meaning we need your financial support on a monthly basis on patreon.com/ljfrench, on sponsors.com/law, or through YouTube membership or Floatplane membership. Thank you very much in April of 2021 to our $50 plus supporters, Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you very much to the $5 plus supporters. Everyone's been scrolling on the updated LED panel behind me and will be on the videos in front of me that drop. I love you all. Have a great week. I hope you all had a nice holiday weekend, and I will see you in the videos. Bye.
Your mum sounded better when she done the gobble gobble.